The modern theory of conflict of laws recognizes and, in any event, prefers the jurisdiction of the state, which has the most intimate contact with the issues arising in the case. Jurisdiction is not attracted by the operation or creation of fortuitous circumstances, such as the circumstance as to where the child whose custody is in issue is brought or for the time being lodged. To allow the assumption of jurisdiction by another state in such circumstances will only result in encouraging forum shopping. Ordinarily, jurisdiction must follow upon functional lines. That is to say, for example, that in matters relating to matrimony and custody, the law of that place must govern which has the closest concern with the well-being of the spouses and the welfare of the offsprings of marriage. The principle of the comity of courts is essentially a principle of self-restraint applicable when a foreign court is seized of the issue of the custody of a child prior to the domestic court. There may be a situation where the foreign court, though seized of the issue, does not pass any effective or substantial order or direction. In that event, if the domestic court were to pass an effective or substantial order or direction prior in point of time, then the foreign court ought to exercise self-restraint and respect the direction or order of the domestic court, or vice versa, unless there are very good reasons not to do so. What then are some of the key circumstances and factors to take into consideration for reaching this final goal or final objective? First, it must be appreciated that the most intimate contact doctrine and the closest concern doctrine of Surinder Kaur Sandhu are very much alive and cannot be ignored only because their application might be uncomfortable in certain situations. It is not appropriate that a domestic court, having much less contact with a child, and having much less close concern with a child and his or her parents, as against a foreign court, in a given case, should take upon itself the onerous task of determining the best interests and welfare of the child. A foreign court, having the most intimate contact and the closest concern with the child, would be better equipped, and perhaps best suited to appreciate the social and cultural milieu in which the child has been brought up, rather than a domestic court. This is a factor that must be kept in mind. Stop.